Have to hurry. We're going to get across the tracks.
We're not going that way.
Have to. John Road's the only one the Yankees haven't touched yet.
Oh, wait, I forgot to lock the front door. What are you laughing at?
That's you, blocking the Yankees now. Haven't got much for the Yankees to take, huh? We'll have to make a dash for it before the fire reaches that ammunition. Take a good look, my dear. This story over. You got your grandchildren, now you watch the old South disappear one night. They were going to lick the Yankees in a month. Poor gallant fool.
They made me sick all of them. Getting us all into this place, swaggering and boasting.
That's the way I felt once about their swaggering and boasting.
Well, Red, I'm so glad you are with the Army. You can be proud now. Proud of you being smart with all.
I'm not so proud.
Who's seen Gone with the Wind? Who's seen Gone with the Wind? How many?
Like 10.
I know. It's so weird. When I sent y'all that email the other day, because I had just seen it in the program listening, and I thought a lot of people, you know, y'all's age haven't yet seen it. And whatever, you got to see it at least once. And I swore I was not going to watch it. I swore I was not going to watch it. And I sat and watched the whole thing. Started out, I said, let me just watch the credits. I just want to hear the theme song. And I'm like, let me just watch the party scene. I'll just watch the party scene. Let me just watch the declaration of war scene. And so finally I just gave up. I made some popcorn and sat and watched. Great. So, that seminal event, let me see if I can figure out how to get the screen. Okay, so that event, we started with our first top line on our three-part timeline, and now we're going to introduce the middle line. And I got to do this in 30 minutes. So we said this top line was going to be U.S. and Supreme Court history, and this middle line is going to be 14th Amendment history. Now, you might say, well, wait a minute, Professor. This is just your class about the First Amendment. Well, we'll get to the First Amendment next week, but we've got to grapple with the 14th Amendment first, because you'll see there's a relationship between the two. And the First Amendment, in some important ways, relies on the 14th Amendment. So we're going along. We said 1857, we had the Dred Scott case. The Dred Scott case, constitutional scholars think of as one of the proximate causes of the Civil War. I mean, obviously, it didn't cause the Civil War. But what it certainly didn't do was it didn't help. It was like pouring gasoline on a fire, right? Remember Dred Scott, the slave who went to a free state and said, I'm in a free state, therefore I'm free. And the Supreme Court said, no, you're not. Not only are you not free, you can never be free, nor can your children be free, nor can your children's children be free, because you can never be a citizen of the United States. The Supreme Court, this is Roger Brooke Taney, the Chief Justice and slaveholder from South Carolina at the time, went so far beyond what the case was about and declared that no African American ever could be a citizen of the United States. So that surely didn't help. Right? You think about us going to these various avenues to try to solve the problem. Well, we have been arguing about it in this realm, in the congressional realm, since the very founding of the country. Remember we said that they came up with those kind of lame compromises in the Constitution? So here we have then turning to the courts and saying, courts, help us. Supreme Court, help us come to a decision about this whole slavery issue. And instead of helping, the court made the whole situation worse. Bitterly divided the country, created a lot of hatred and disrespect for the court. We think of it as this great self-inflicted wound. So then here we go. So 61 to 65, right? The great unpleasantness, the war of northern aggression. One thing we can do is we can think in broad terms what we can do is we can think from, I guess we can go all the way back. We can say from 1789, which is the writing of the Constitution, we have the de jure slavery period. Before that, pre-1789, we could just say it's the de facto slavery period, at least in terms of at the federal level. What's the difference between de jure and de facto?
One is by custom or tradition, and the other is by law.
Right. So de facto
Is by custom or
the facts on the ground say that this is how it is. So we didn't have, we hadn't even written the Constitution yet. So at the federal level, we hadn't said anything about slavery in terms of our Constitution. But then we get now slavery by law, because remember, we had this chance when we wrote the Constitution. We had a chance right then to solve the slavery problem, but we did not, did we? Right. So then the de jure slavery period lasts, and we continue fighting about it, and then it finally ends with passage of the 13th Amendment, which does what?
abolishes slavery.
It finally abolishes slavery. So the 13th Amendment does that.
Sorry, what year is the 13th one we're talking?
I want to say,
Is that 60?
wait a minute, 68. Somebody Google it for me. Is it 1763? Someone Google that for me and give me the date. I mean, someone Google it for me.
1864.
64, I'll talk about one. Okay, 1864, and then we get the
Well, it was adopted in 65.
adopted,
Passed by the Senate in 64.
and then when was it ratified?
65.
Okay, thank you. 65, and then the 14th was ratified in 68. We'll come back to that. And then remind me of the date on the 15th when it was ratified. What did the 15th do?
Gave voting rights and citizenship to slaves, both present and former.
Gave voting rights. Gave
70. 1870.
1870. Gave voting rights to African American males. Right? Women, y'all were still third-class citizens. White and black. Right? And so then we can say, so now we no longer have the slavery era up to here, because it ends with the ending of slavery. And so then we can call this period, throw this up about right here. We're going to say, as a legal matter, Reconstruction, military Reconstruction of the South, meaning Yankee troops stationed in the South military Reconstruction ends in 1877. But the era of Reconstruction really lingers through the end of the century, and it really takes because remember we said that often legal rules or legal regimes shape the world around us, whether people realize the way that the law structures. our world or not. But so we get the Reconstruction era, right, ending in terms of our legal framework with Plessy v. Ferguson. With Plessy v. Ferguson. That's what, and then we'll say, we'll come back to that.
And that was separate and equals okay, right?
Yes. But we'll talk more about that. Well, let's jump back then. And let's look at the 14th Amendment. If you can have it on your screen, or you can bring it, if you printed it out, we can look it up, look at it together. I actually want to look at this on the screen. Now, so we said that Article 5 of the Constitution spells out the amendment process and tells us how to amend the Constitution. So we get to the end of the Civil War, and obviously our constitutional system is completely broken and has fallen apart. And so we need to fix it. And we fix it by passing these 3 amendments, 13, 14, and 15, called the Reconstruction Amendments. The Reconstruction Amendments. And it significantly changed our constitutional system. So remember, if you go back in your notes, we had the structure. It was bubble number 1, 2, and 3. It was federal government, state government, and the individual. And we said that the middle bubble is the state government because it's going to act as a buffer to protect the individual from the federal government. Well, the state governments hadn't done a very good job of protecting individuals, had they? Right. How good a job did the state governments do protecting women? Not at all. You couldn't vote, you couldn't own land, you couldn't sign a contract, you couldn't go into law, you couldn't go into medicine. You were basically the property of your husband. How good a job did the states do protecting Native Americans? Not good. We killed them. Right? How good of a job did the states do protecting African Americans? Not at all. Right? So what we have then, the way you can think of it is this, is if we started out with the idea that the state governments would act as a buffer to protect individuals, this is individuals, state govs, federal government. With the 14th Amendment, think this is a way to visualize it. The federal government, for the first time then, inserts itself right there. I mean, it's with the writing of the 14th Amendment, the federal government is basically saying, no state governments, we don't trust you. We are going to act as a buffer to protect individuals. That was a very radical change. So we think about the 14th Amendment as the second Bill of Rights because it introduced a whole other basket of rights that did not exist before then. And there's a very important point to make here before we go any further. The 14th Amendment was written because of slavery and because of the Civil War and because of the need to protect African Americans, but it created strong and enduring rights that apply to us all, right? So the benefits of the 14th Amendment redound to us all, not just African Americans, but it was the struggle for freedom. It was the black struggle for freedom that ended up creating these powerful rights for all of us. Now, the very first sentence, here's another example. Remember when we said, if the Supreme Court in Marbury v. Madison gave itself and itself alone the right to say what's constitutional, and in the Dred Scott decision it said that African Americans never could be citizens. Does the debate end there? Is there any way that we can trump that Supreme Court decision? How do we do it? How do we trump the Supreme Court decision? Article 5 tells us how to do what? us how to do what? Amend the Constitution. Because remember, the Supreme Court doesn't write constitutions, it only interprets the Constitution. So if we don't like something the Supreme Court has done, the way we can trump the Supreme Court is by rewriting the Constitution, by amending it, which is what the 14th Amendment does. And so the very first sentence, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Do you hear this? The people are talking back to the Supreme Court in that sentence. They're saying, no, Supreme Court, you got this wrong in Dred Scott. You're wrong, and we are now trumping you. All persons born and naturalized in the United States, meaning all African Americans who were also born and naturalized in the United States, are citizens. Right? You see that? We literally turn around. The amendment process is how we get to talk back to the Supreme Court. No state. Now this is, at the time, with radical language. For the federal government to come around and say, no, we're going to set the rules for the states. That's very different. Because remember we said we wanted the states to be calm. Now here's the federal government saying, no, we're going to tell you what to do. No state shall make or enforce any law which shall abridge the privileges or immunities of any citizen, nor shall state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. 3 clauses. What does that remind you of? What does that structure remind you of? 3 clauses separated by semicolons. What does it remind you of? The First Amendment. And if we said with the First Amendment there are 6 clauses, therefore 6 rights or freedoms. Right? So 3 clauses giving us 3 distinct rights and also 3 litigation strategies. If you are going to accuse the government of violating your 14th Amendment rights, you can say, you violated my 14th rights under the Privileges or Immunities Clause. Or you violated my 14th Amendment rights under the Due Process Clause. Or you violated my 14th Amendment rights under the Equal Protection Clause. So the 14th Amendment in Section 1 does 2 important things. Number 1, it rejects Dred Scott, it nullifies Dred Scott, and it gives citizenship to African Americans from that time forward. And number 2, it creates 3 distinct rights that will apply not just to African Americans, but as time goes by to everybody. And you'll see in constitutional law that these rights that were originally designed to protect African Americans end up being two of them end up being 2 of the strongest rights that all of us have: the Due Process Clause and the Equal Protection Clause. Okay, let's go back to it. Very important language. So I wanted you to see that and have a printout so you could see it, so you could see how, law is all about words and interpreting words and when legislators write law, they have to choose their words carefully, and then because of some court somewhere is going to have to interpret these laws over time. Because when they write it down on paper, we don't know what due process means exactly, or we don't know what equal protection means exactly, because we haven't seen how it plays out. So we've got to see some court cases. So we get the 14th Amendment on the books in 1868. And now remember, the wounds from the Civil War are still pretty raw, right? And you have, one half of the country bitter and pissed off because they lost the war. And there's a lot of politicking going on in Congress. A lot of Yankees wanted to really stick it to the South for starting that very stupid war. So anyway, very fraught period. The 14th Amendment, some people looked at it and thought it went too far. They were afraid that it was going to go too far. And the courts the Supreme Court was very leery of interpreting it in a really broad way.
Didn't they use the 14th Amendment to talk about abortion at one point?
About what?
About, like, and as one tenet of the argument in Roe v. Wade?
Well, Roe v. Wade is a 14th Amendment case. You'll see. Let us get there, because we're still in the 19th century. So we gotta see what's going to happen as cases come up. And I suppose (1873) the slaughterhouse cases is the first important one we have to keep in mind. So the slaughter, don't worry about what it was about. It's a confusing case and the details aren't important anyway. All that's important is what the holding did, the significance of it. Right? So we had the 5 years after the 14th Amendment is ratified, the ink is barely dry, and the slaughterhouse cases, the case was litigated. Remember, we have 3 clauses, therefore 3 rights, therefore 3 litigation strategies, and the slaughterhouse cases was litigated under the privileges or immunities clause. And the court's decision was so strong that the people not only lost their case, but the Supreme Court essentially, and we say it this way, closed down the priv or immunity clause. And to this day, from 1873 to this day, you cannot litigate a case under the privileges or immunities clause. You could try, but you would be laughed at. You see that? We got 3 clauses or 3 rights, and the Supreme Court basically erased one out of the 14th Amendment. So from that point going forward, it left us only 2 important clauses or 2 important litigation strategies in Article 1 of the 14th Amendment, and that's due process or equal protection. You see that?
What were the 2 clauses under slaughterhouse?
Slaughterhouse cases closed down the privileges or immunities clause.
Thank you.
That was that first one. But it still left the due process clause and the equal protection clause. So those would grow in importance over time. In 1875, Congress passed the first Civil Rights Act. The first Civil Rights Act. I'm putting it up here on this top line, so this is U.S. history. Congress passed the first Civil Rights Act in 1875. Now, it did a bunch of things, but the part that we're particularly interested in was this. It barred discrimination in public accommodations. What are public accommodations?
Bathrooms, water fountains, stuff like
What else?
Hotels.
Hotel. Did you say hotels? Okay, what else? Hotels,
Restaurant?
restaurants. What type of places are hotels and restaurants? Does the government own the restaurant? So it's not public property, right? So what kind of property is it? Private property.
that. Isn't it supposed to be open to everyone?
Now see, there's the rub. It's private property, like you own it, but it's a business, so you want people to come in it, don't you? And so that's where we get a very special phrase, a public accommodation is the term of art. It's private property that has been opened by the owner's choice to the public. And what the 14th Amendment did was it barred discrimination in public accommodations. Theaters, restaurants, hotels had to let African Americans in. What do you think the white people in the South thought of that?
You probably didn't like it.
Right?
A few people probably liked it.
And so 1883, we get the civil rights cases of 1883. The civil rights cases of 1883. I'm going to say bar, this, in, pub, act. Bar discrimination and public accommodation. And then we get the civil rights. So the whites challenged it. The whites challenged it as unconstitutional under the 14th Amendment. And they won. And so the Supreme Court struck down as unconstitutional the Civil Rights Act of 1875. But it's not only that that makes it important and makes, I need a red magic marker to write this. So they said the idea was this then. They said that a hotel or a restaurant or a bar is private property. Is private property. And so if you try to claim that he violated your 14th Amendment rights, it's private. First of all, it's private. And we said, remember, property is very, very, very important law, especially in that era. We talk about the primacy of property. It was the most important type of law. So for one thing, it's private property, and you shouldn't be able to interfere with his control of it. But here's the really important part of it. If you go to the 14th Amendment, remember when we talked about negative and positive rights? A negative right is about what the government can't do to you. Well, that's what the 14th Amendment is about. Because remember, it says, no state shall do such and such. Is this guy, the private hotel owner, is he part of the government? No. So the 14th Amendment couldn't apply to him. Because remember, it says, no state shall do such and such. That's all about what the government can't do, not about what a private person can do. And so the court creates a very important rule. You cannot leave this class until you understand this, because most people do not understand this about the way constitutional law works. State action doctrine. It's one of the most important doctrines in all of constitutional law. State action doctrine stands for the proposition that without government involvement, no constitutional claim can be made. Constitutional law, remember we said it's about the relationship between the individual and the state. Constitutional law isn't about regulating the conduct of two private individuals. So without government involvement, no constitutional claim can be made. State action doctrine stands for the proposition that without government involvement, no constitutional claim can be made. This is the biggest mistake that people make when they talk about the First Amendment. You can't sue her for violating your First Amendment rights. She's not part of the government. You can't sue me. I can tell you to shut up. Don't ever speak for the rest of the semester. And if you try to sue me as an individual, a private individual working for a private institution, it would be a 12b6 motion to dismiss failure to state a claim. You wouldn't have a claim. I'm a private person. This is a private institution. Right? We are just two private people. If Netflix decided it doesn't like Michael Moore's political viewpoints, and so it's not going to carry any of his movies, and Michael Moore sued Netflix and said, you violated my First Amendment rights. Now, all of you would chuckle knowingly, because you know that Netflix is a private company that cannot violate that guy's First Amendment rights.
So you told him to shut up when we were at a public institution, would be any different?
Yes, it would be different. If we were at Chapel Hill, he could sue. I don't think it was just telling him to shut up. I would have to violate his or abridge his speech. But you're exactly right. Everything we talk about in this class is different when I teach this class, or a lot of the examples we use in this class are different when I'm over at Chapel Hill. Right? This university can abridge your speech. This university can abridge your freedom of the press. This university can close down the school newspaper as it did some years ago. And it didn't violate the students' First Amendment rights. If that happened at UNC, well, it would be a political firestorm if that happened at UNC. But that's a very important distinction to hold in mind. Where you are, whether you're talking about a private, property, private institution versus public property, public institution, is a very important distinction. We'll have to finish up when we reconvene on Tuesday. We'll finish up talking about the 14th Amendment and begin talking about all of the material for next week and probably into the week after, but definitely next week is chapter 2 and 3. Chapter 2 and 3.
I just want you guys to know.
Yeah.
Literally.
No, actually.